So next month, the US Supreme Court will now hear a critical Second Amendment case which aims to stop the ATF's current Second Amendment violations. So let's talk about what is happening. But real quick before we jump into this video, if you think it's time for the Supreme Court to strike down the ATF's current Second Amendment overreach, go ahead and hit that like button and subscribe. I also want to thank one of the new sponsors of the channel, which is First Form. A lot of you guys have seen me put up some posts over on Instagram and then here also on the channel talking about that I've lost about like 54 pounds over this last year. And I finished off the year doing the 75 hard program. And one of the big things that I've used during that whole process was First Form, their supplements, and then also the 75 hard program. Awesome supplements. I really enjoy their protein a lot. I also really like their energy drinks. They're about 0 calories, I think, for almost all of them. Check them out. You can look at them using the links down below. And again, thank you to First Form for sponsoring and supporting this two-way content. So as I mentioned in the intro, in this video, we're going to be talking about a huge Second Amendment case that the Supreme Court will now hear oral arguments on next month. The case is actually a direct challenge to the ATF's current overreach with bump stocks and the regulation of those items as actual machine guns. This is also a challenge to the ATF's ability to flip-flop back and forth on what they are actually determining to be certain items. And this is something that the ATF has done not just with bump stocks, but other items as well, which directly affect you, like pistol braces, unfinished frames and receivers, and other items that they potentially will want to target going forward. As many of you know, the ATF has been redefining various items and making them subject to the NFA and GCA's restrictions. And one of the first items that they did this with was bump stocks. The ATF arbitrarily decided to go back on years of guidance and then suddenly say that bump stocks on their own are in fact machine guns. The new restrictions were challenged in a case called Cargill v. ATF, and as a result, we received a major Second Amendment win coming out of the Fifth Circuit Court of Appeals out of an en banc panel. The Fifth Circuit en banc panel ruled in Cargill v. Garland that the ATF's final rule on bump stocks is in fact invalid. This decision struck a major blow to the ATF's current overreach and their claimed authority, and it's important, and this decision is very important, because it then forced the ATF to actually have to go to the Supreme Court on their own and ask for the Supreme Court to review this issue. So early in this year, there's going to be a critical battle over 2A rights and also administrative overreach, which is going to take place in the Supreme Court. Now, for those not aware, one of the important aspects of this challenge was whether Chevron deference should be given to the ATF in relation to their final rule on bump stocks, or whether a different rule, something like the rule of lenity, would direct courts to rule in a way that is more favorable to us, the people, not the agency, the ATF. If you're not aware of what Chevron deference refers to, Chevron deference is a term coined after a landmark case referring to the doctrine of judicial deference, which is given to administrative actions. Now, generally, for an agency to be given Chevron deference, the agency's interpretation of an ambiguous statute must be deemed rational or reasonable. So when a statute maybe has an ambiguous term, the agency responsible for enforcing that statute may be able to determine what the term is intended to mean, as long as their interpretation is deemed rational or reasonable by the reviewing court. Now, Chevron deference is only one type of doctrine that can be used in these types of cases. There are also a lot of other doctrines like the rule of lenity. Now, in a 13-3 decision, the en banc panel in the Fifth Circuit found that the ATF did in fact overstep their authority in regulating bump stocks as machine guns under the GCA. The en banc panel stated in their ruling that a plain reading of the statutory language paired with a close consideration of the mechanics of a semi-automatic firearm reveals that a bump stock is excluded from the technical definition of machine gun set forth in the GCA and the NFA. In the decision, the Fifth Circuit en banc panel clearly identified that the definition of a machine gun in the GCA and the NFA does not include items like bump stocks. And even if the term were considered to be ambiguous or vague in some way, the court concluded there that the rule of lenity would direct them to interpret that term or ambiguity in a way that is more favorable to the people, not the ATF, and therefore bump stocks could not be considered to actually be machine guns. They also went on to state that if Congress or the ATF wants to be able to include these items in the definition, well then the burden is on Congress to change the statutory definition. But the ATF on their own does not have the power to change definitions and then place criminal implications and criminal convictions on their own. So they can't just do this on their own. They cannot be judge, jury, and executioner. They do not have that power. Now, after the Fifth Circuit issued that decision, and now that Hardin and some of these other cases have been decided, the ATF was forced to file for Supreme Court review of those decisions. And the Supreme Court did, in fact, grant review of the Cargill case. Now, the question the Supreme Court will be hearing and reviewing during their oral arguments is very simple: whether a bump stock is a machine gun as defined in 26 U.S.C. 5845 subsection B. So again, a pretty straightforward issue that has broad implications for all other ATF regulatory actions. Recently, the ATF filed their first brief to the Supreme Court in this case, and in it, they make some huge admissions and then also some huge mistakes. This is likely because they have been backed into a corner based on their prior actions and also some of their prior statements on these specific items. Also, the fact that Chevron deference is likely going to be done away with very soon makes most of their traditional arguments that they would use no longer viable. So now they're coming up with new arguments, and because of that, they're making a lot of mistakes. The ATF argues that the Fifth Circuit en banc panel got this issue wrong because, in their words, the statute is most naturally read to focus on the shooter's interaction with the firearm rather than the firearm's internal mechanics. They also argue that the Fifth Circuit should not have invoked the rule of lenity. They argue in their brief that finally the Fifth Circuit invoked the rule of lenity, but that rule comes into operation only if, after the application of all other tools of statutory interpretation, the statute remains grievously ambiguous. No such grievous ambiguity exists here. What is interesting about this specific argument that the ATF is making is that it's 100% false. The Fifth Circuit en banc panel did not just jump to the rule of lenity first. Actually, what they did is they did a plain reading of the statute. They looked at a bump stock, they looked at the terms in the statute of the NFA and GCA, and found that under the clear intent and also the clear text of the definition in the statute, these items are not machine guns. And then the Fifth Circuit argued that even if there was an ambiguity in the definition, well, then you would not use something like Chevron deference. They said at that second step, you would use the rule of lenity. So it's not like they just automatically jumped to the rule of lenity. They did kind of a two-step analysis. And then the ATF makes a huge admission and a huge mistake in their brief. They admit that their prior guidance on this issue clearly stated that bump stocks do not meet the definition of a machine gun. They do not meet the definition under the NFA or GCA, and they've come to that conclusion multiple times in the past. But now all of a sudden they are changing their position. That, of course, is a huge admission to make to the Supreme Court when you're now going to go in front of them and try to justify your new interpretation of these items as actual machine guns under the NFA and GCA, when you clearly and obviously admit that there have been multiple times in the past when you say that these items are not machine guns. And it's even more critical when your current position is based on you saying that the text of the GCA and NFA is so clear and plain that these items are included in the definition. But how could you argue that the text is so clear that there is no ambiguity when your prior conduct and prior interpretation is to the contrary? And all this is going to be huge when the ATF now has to step in front of the Supreme Court and try to justify their current overreach. The Supreme Court just recently set this case for a hearing and oral arguments on February 28th. So at the end of next month, the ATF now has to face the Supreme Court and try to justify their actions and their flip-flopping of their position, and then also just their violations of the Second Amendment. These arguments, I think, will be very interesting, especially in light of the Supreme Court's current interest in doing away with Chevron deference. The Supreme Court has issued multiple decisions even just last year, which significantly curtailed Chevron in the context of the EPA and then also student loans. They also currently granted review to multiple cases on the direct question of whether or not they should completely do away with Chevron or at the very least constrain it significantly. So in the context of other agencies like the EPA and some others, they face the drastic impact of doing away with Chevron, and that has been directly resulted to somehow the Supreme Court decisions directly related to those agencies, and now it seems like it's the ATF's turn. So I'll definitely be listening to those oral arguments, and then when they happen, I will also share it with all of you guys. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, as all of you OGs know. It helps to signal to the YouTube algorithm that you guys see value in these videos, and then also in this type of 2A news. And then I just want to mention that you guys might want to double check your subscriptions because YouTube loves to unsubscribe people. And then also, if you're not subscribed to the channel and you watch these videos often, please consider subscribing. One of the goals is to reach 600,000 subscribers, and we're approaching that really quick. So again, love you guys' support. But regardless, thank you guys so much for all your support. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.